FH. The court recognizes here before the court Mr. Sean Van Ackle, an agent from the Michigan Department of Corrections, and author of the request and warrant for probation violation in this file. Joining me today via Zoom from the Wexford County Jail is Mr. Kenneth Schutz. Mr. Schutz, can you see and hear me, sir?
Yes, sir.
Thank you. Mr. Schutz, we are here today for an arraignment on a request and warrant for a probation violation. I must tell you what the two charges are, what your rights are, what your possible consequences are, and then see how you wish to respond. Count 1 alleges that you violated special condition 4.18 of your probationary terms. That condition requires that you must not engage in any assaultive, abusive, threatening, or intimidating behavior. And more specifically, it's alleged that on or about October 29th, 2023, you sent messages to an individual named Heidi Tweedy that were assaultive, abusive, threatening, or intimidating. Count 2 alleges a violation of Rule 1 of your terms and conditions of probation. Rule 1 requires that you are not to violate any criminal law of any unit of government. And more specifically, it's alleged that, before I continue, Mr. Van Ackle, is that a correct date? It says June, but the other one said October.
Yes, Your Honor, that's correct.
It's June 29th. So, Mr. Schutz, it's alleged that on or about June 29th, 2023, you damaged property belonging to Heidi Tweedy. You have the right to challenge these two allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you'd have the right to be represented by an attorney as well as all subsequent proceedings. You also have the right to have the prosecutor prove the allegations by a preponderance of the evidence. At that hearing, you have the right to review the evidence presented against you, question and cross-examine any witness presented against you, as well as the right to present witness evidence or testimony if you chose to do so. If you're found to be in violation of your probation, you would be resentenced on your original offense. In this case, you were originally convicted of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days and or $300 and or 360 hours of community service. Now, there are two allegations that I've mentioned. One of them is a technical violation. The one that alleges that you had engaged in some kind of assault, abusive, intimidating, or threatening behavior is a technical violation. Is this a first technical, Mr. Van Ackle?
Yes, Your Honor.
For a technical violation, the court is limited to a punishment of no more than 15 days. However, because count 2 is a non-technical, which is because allegedly it's a new criminal offense, the court would not be limited to a sliding scale. Now that I've told you what the two allegations are, what your rights are, and your possible consequences are, I need to know, how do you wish to respond? We don't, in circuit court, we do not often have convictions for just misdemeanors, but in this case, because it was just a misdemeanor, for technical offenses or probation violations, the court's limited to a sliding scale, and is it 5, 10, 15?
Yes, Your Honor.
So the most the court can give you for count 1 is 5 days. For the second, the count would not be limited to that sliding scale. All right. Now that we know that you aren't pending any new criminal charges in any court, the question I need to know is, next, do you have an attorney hired, or do you plan to hire your own attorney, sir?
I don't have one hired.
Okay. Do you plan to hire one?
I don't think so. No.
Okay. The next question is, do you want the court? Hold on, let me tell you this. If you ask for, and by the way, there's no pressure from the court. If you ask the court to appoint a hearing, that could take place as early as the next couple days. But to plead guilty, I'd have to have you describe to me what it is that you did that makes you guilty of this offense. So the question again is, do you wish to have it set for a contested hearing, or do you wish to admit guilt?
I admit guilt.
Okay, please raise your right hand, Mr. Schutz. Sir, do you swear or affirm that the information and testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
You may lower your hand. Mr. Schutz, are you willing to waive your right to have a contested hearing and make the prosecutor prove these allegations by a preponderance of the evidence?
I am.
Are you willing to waive your right to have an attorney to assist you both in the findings as well as sentencing in this case?
Yes, sir.
Has anyone made any promises, threats, or inducements to force or compel you to admit guilt and waive those rights?
No, sir.
All right, as to counts 1 and 2, how do you plead?
Guilty.
Before the court can accept your plea, I must have you tell me what it is that you did that makes you guilty of the offenses. I'm going to look here at count 1. Count 1 alleges that on or about October 29th, which would have been last week, you sent some messages to an individual named Heidi Tweedy that were assaultive, abusive, threatening, or intimidating. Who is Heidi Tweedy to you, sir?
My ex-girlfriend now. Girlfriend at the time.
Okay. And did you send her some message last week?
Yes.
And how did you send that message? For instance, was it an email, a text, an instant message through social media?
It was a text message.
Okay. And what did you say in the text message, Mr. Schutz?
Something along the lines of, she didn't know who I am, and she can't get away with, she can't keep getting away with, doing this to me, and that, there would be consequences, and I needed to learn how to stop myself, and I will.
Did you describe what you meant by the word consequences?
No, I should have though.
Okay. And what was your intent for making this statement or these statements to Miss Tweedy?
Suicide.
In other words, you were threatening to harm yourself. Is that correct, sir?
Yes, sir.
Okay. Now, there's this allegation that back on June 29th of 2023, in other words, about 4 months ago, you damaged some property belonging to Miss Tweedy. Could you explain that to me, sir?
Yes, sir. Heidi was at my house the following Sunday, that Sunday, and I called her when she went on her way home. I called her, and we talked for a little while. Then she got home, and later on, I tried to call her. I couldn't get a hold of her, so I drove to her house, probably about 8 o'clock, I believe it was, to make sure she was okay. Because prior to this, nothing like this had ever happened yet. And when I got there, there was no cars and no lights on. I knocked on the door, no answer. So I used my house keys that she'd given me to enter the front door. And when I did, she came out of the bathroom real fast, which was connected to the master bedroom. She came out the bathroom, so I couldn't see in the bedroom. And that's when I knew right away that she had another guy in there with her. And we talked on the porch for a moment. And I asked her to get rid of the guy, take him wherever you need, or, just make him leave. And that's when she told me she needed to take him down the road to the church parking lot because his car was hidden there. And she didn't want his car at her house. And
What did you what did you damage?
Well, I'm trying to get to that point real fast. Sorry, sir.
It's okay.
She never came back, and after I realized she wasn't coming back, that's when I overdosed myself on what do you call them? Antihistamine products, allergy pills. That's what they were, and Tylenol.
Yes, sir.
Until I passed out. And I remember vaguely having a real hard time walking to the bathroom. And the property that I damaged was, I believe, her mirror in her bedroom. I kind of ran, or in her bathroom, sorry. It was open, and when I went into there to use the bathroom, I kind of slammed it, and it slammed too hard and cracked the mirror. And the door, when I opened it, I guess I opened it too hard, and the door handle went through the wall. And at one point, I stumbled forward and my head went into the drywall and damaged it a little bit.
Okay. Did you do this while you were angry and upset? Is that how these things happened?
No, honestly, I didn't even know what was going on at that point. And then I woke up in the Midland Hospital.
So did you intentionally cause this damage?
I don't believe so, sir.
Okay.
I believe it was more from not being able to control my walking and stuff very good. I kept stumbling.
Hold on one moment. Yes, sir, Mr. Van Ackle?
If that is insufficient for a finding of guilt, I have no witness to rebut his statement, as the victim was not present when this occurred, so.
Okay. All right. So, thank you, Mr. Schutz.
Mhm.
All right. The court finds the defendant guilty of count 1 of the 2 violations without any further testimony to find the defendant intentionally damaged the property. I'll find the defendant not guilty for count 2. That means the most the court could give Mr. Schutz today is up to 5 days. Was he apprehended yesterday or today?
Today.
Okay. Mr. Van Ackle, your recommendation as to a sentence, sir?
This is his first and only criminal conviction. Up until this point, I was unaware of the June issue until yesterday. Up until this point, I was under the impression he was doing well. He has been working on community service.
Good.
I would recommend counting today as 3 days jail credit. Recommend jail at the court's discretion, and an added condition of no contact with.
Okay. Mr. Schutz, are you currently working at this time?
No, sir. I applied for Social Security, and I'm waiting back. That should be happening anytime.
Okay. And this relationship with this individual has ended. Is that correct, sir?
Yes, sir. That's correct.
All right. So you said he has 3 days credit?
Counting his arrest today, yes.
All right. When was the conviction? I see that the information was back in April of this year. Let's find out when the conviction occurred. What was that date? Looks like it was the 12th of June. I see the 12th of June. Looks like he was given.
Oh, he was sentenced on. Yes,
Yeah, I'm sorry. Thank you. Thank you. All right. Mr. Schutz, is there anything you wish to add today? You have the right to be heard before the court gives a sentence today, sir.
Just that I will not get into any more trouble, I promise.
Right, all right. Well, Mr. Shute, sometimes people make bad choices. Sometimes it's while they're under the influence of whether it's a over-the-counter or illegal controlled substance, or maybe there is alcohol involved. I know here in your original case, it looked like it involved some alcohol. But I don't have any evidence that alcohol was involved here. It just seems to be, this is a little bit of a surprise. I don't think, as Mr. Van Ackmo stated, it looked like you have been doing pretty well on probation. Yes. So the court is going to continue probation. Has he made any payments on fines and costs, Madam Clerk?
They're paid in full.
And you've done a great job paying your fines and costs. So therefore, sorry, therefore, the court again continues probation. This is you to 3 days, but gives you 3 days of credit, which means you should be let out here before the end of the day. Do you understand, Mr. Schutz?
Yes, sir. Thank you, sir.
All right, Mr. Schutz, let's make sure this is a lesson learned. Oh, wait, the court's going to add a term or condition of your probation that you are not to have any contact with this individual, Miss Heidi Tweedy. And Mr. Van Ackmo will prepare a amended added term or condition of your probation. And that way it just helps keep the peace between you and this individual.
Yes.
Now you're going to receive, and will you handle this, Mr. Van Ackmo? Who's going to do the advice of appellate rights? Can you handle that, or? Hold on.
Your office typically sends them.
My office will send it to you, sir. My office does stuff that I don't even know about. They're so good. So you're going to receive in the mail 2 copies of one document. You will place your initials on one copy and return it back to the court. When you place your initials on that copy, you are neither electing nor waiving any rights. You are merely acknowledging receipt of the copy of the other document. I'm sorry. The other copy of the document. Thank you. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the nature of the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney for you, you must return that document within 42 days. Now, if you choose not to appeal, you may simply dispose of the document. Of course, you're about to be let out here in a few minutes, so there's not a whole lot to appeal, but that's your right to do so if you so choose. Do you understand, Mr. Schutz?
I do. Yes, sir.
All right. Now, my last thing that I'm going to say to you, are these parents here in the courtroom? All right. Mr. Schutz, I understand that emotions can run high when there's a breakup of a relationship. I really hope that you are in the right place mentally for yourself. Do you understand, sir?
Yes, sir. Thank you. I am.
If you have any concerns about or thoughts of harming yourself, please contact your parents or contact your probation officer or contact somebody at Community Mental Health, because we would really hate to see something bad happen. Okay, sir?
Thank you. Yes.
All right. Thank you, sir. Thank you. We're adjourned.